Did you know that saying no to a breathalyzer in Oklahoma automatically triggers license revocation for at least 6 months? And that's just the beginning of your problems. Today, I'm breaking down how Oklahoma's implied consent law works, what really happens when you refuse testing, and why the police officer might still get that blood sample anyway, with or without your permission. Before I continue further, I'm that attorney Lai. If you like my videos about the law and interesting law-related topic, please press that like button, subscribe, and click on the notification. So mistake number 1, thinking refusal means no DUI. Let's talk about the first critical mistake many drivers make, believing that refusing a breathalyzer test means you can't be convicted of a DUI. This dangerous misconception has serious consequences. I've seen countless clients walk into our office shocked after being charged with DUI despite refusing the breath test, but they have no proof, they insist. The reality is far more complicated. In Oklahoma, prosecutors don't need a breathalyzer reading to build a compelling DUI case. When you refuse that test, officers immediately shift to documenting everything else about your condition. Those bloodshot eyes noted in the report, the smell of alcohol carefully described, your unsteady walking or slurred words, all meticulously recorded. Today's police vehicles are equipped with dash cameras capturing your driving patterns before the stop, weaving, missing stop signs, or erratic speed changes. Body cameras record your entire interaction with the officer, preserving every word and movement for the jury to analyze. Even if you decline field sobriety tests, the officer will testify about your refusal and any observations made during the attempted test. Did you sway while standing? Did you have trouble following simple instructions? These details become powerful evidence. Perhaps most damning is how prosecutors frame your refusal itself. They will argue to the jury that you refused testing because you knew you would fail, what legal experts call consciousness of guilt. This interpretation often resonates with jurors who wonder why an innocent person would refuse. Consider the case of Oklahoma v. Johnson, where the defendant refused all testing but was convicted based solely on officer testimony and video evidence showing clear signs of impairment. The jury deliberated just 45 minutes before returning a guilty verdict. Mistake number 2, misunderstanding Oklahoma's implied consent law. That guilty verdict was just one part of Johnson's nightmare. What most drivers don't realize is that refusing a breathalyzer triggers automatic penalties to your license before you even step foot in the courtroom. Did you know that simply by turning the key in your ignition, you've already made a legal agreement with the state of Oklahoma about chemical testing? This is Oklahoma's implied consent law, and it means that just by driving on Oklahoma roads, you've legally consented to chemical testing when suspected of DUI. The consequences kick in immediately and operate completely separate from any criminal charges you might face. Here's what happens the moment you refuse. The officer seizes your license right there at the scene and completes an officer's affidavit and notice of revocation disqualification. You'll receive a temporary driving permit that expires in just 30 days. After that, you're facing a minimum 6 months license revocation, not suspension, even if you're never convicted of DUI. The clock starts ticking immediately on a critical 15-day window. That's all the time you have to request an administrative hearing through the Department of Public Safety to contest the revocation. Miss this deadline and your driving privileges automatically disappear when that temporary permit expires. Oklahoma's penalties get significantly worse for repeat refusals. A second refusal within 10 years results in a 1-year license revocation. A third refusal? You're looking at 3 years without driving privileges. And once the revocation period ends, you're not done yet. You'll be required to install an ignition interlock device in your vehicle, potentially for up to 5 years, all at your own expense. Don't think refusing means you've avoided chemical testing altogether. In serious cases, especially those involving accidents with injuries or fatalities, officers can obtain a warrant to draw your blood despite your refusal. Mistake number 3, not knowing your legal rights and options the moment officers take your license after a breathalyzer refusal. A hidden countdown begins that most Oklahoma drivers never realize exists. While the state has already positioned itself against you through implied consent laws, powerful legal defenses remain available, but only if you act within that crucial 15-day window to request an administrative hearing. This hearing represents your opportunity to contest a license revocation completely separate from any criminal DUI case you might be facing. Many drivers mistakenly focus solely on their criminal defense while letting this administrative deadline pass, essentially surrendering their license without a fight. At this hearing, an experienced attorney can challenge whether the officer had legitimate reasonable suspicion to initiate the traffic stop in the first place. Perhaps the officer claimed erratic driving that dashboard camera footage doesn't support. Your lawyer might also question whether proper protocols were followed during the stop itself. Was the breathalyzer device properly calibrated? Did the officer have reasonable cause to believe you were intoxicated? Medical conditions can provide another avenue for defense. Certain health issues might explain physical symptoms officers misinterpreted as intoxication or could have prevented you from physically complying with testing procedures. This is why gathering evidence immediately is critical. Medical records, witness statements, and any available surveillance footage can fundamentally alter your case outcome. Even when full reinstatement isn't possible, Oklahoma offers modified suspension programs that could preserve limited driving privileges. With proper representation, you might secure permission to drive to work, medical appointments, or other essential locations during what would otherwise be a complete revocation period. The Oklahoma Department of Public Safety hearing process involves complex procedures that few drivers can successfully navigate alone. The Implied Driver Accountability Program and potential ignition interlock requirements add additional layers of complexity that an attorney can help you understand and potentially minimize. So, let's wrap up what we've learned today. Armed with knowledge about Oklahoma's implied consent law, you're better positioned to make informed decisions if ever stopped on suspicion of DUI. The stakes are incredibly high, from substantial financial penalties to long-term license consequences. For those who have already refused testing, remember that time is critical. The moment police seize your license, that 15-day clock starts ticking. Missing this deadline guarantees automatic penalties. Every traffic stop presents unique circumstances and evidence. The right approach depends entirely on your specific situation, from the reason for the initial stop to the officer's observation and documentation methods. Knowledge is truly your strongest defense. Last piece of advice: if you want to avoid the high, hefty legal fees and an attorney to defend you, don't drink and drive. Get an Uber, get a taxi, get a friend to drive you. Please don't drink and drive. See you next time. Bye.